court. Neil Rose, representing the respondent, Charles McCravy.
Mr. Rose, the one area I have a really tremendous concern with in this case, and if you'll turn with me, you probably have the decision in front of you from the 3rd District, but it's the last paragraph where the 3rd District announces why, the principle of law as to the conclusion. And there, the 3rd District says, we reach this conclusion because the 6 administrative orders recite as its authority, and it gives the article of the Constitution, grants this court the power to, quote, adopt rules for the practice and procedure in all courts, not to modify statutes. Furthermore, we have the Florida Supreme Court itself, and it gives the case name, specifically declaring that by enumerating 8 grounds in the statute, the legislature has basically precluded application of any other tolling provisions that imaginative litigants may come up with. My concern with that announced conclusion is that there is no authority even for one of these orders. That if there's a catastrophe hits an area, that it doesn't toll a thing. And that may be the answer. It may be the Constitution does not give us that power. But what we need to be sure that we know, everybody knows what the law is, and not be operating from different positions. And I'm sure arguments can be made either way, but I'm concerned with that announced reason for its holding. Could you help me with that?
It's my position that the court has the constitutional power to enact rules in terms of practice and procedure of the courts. And then you also have the rule of judicial administration that allows you to enter into such orders when you have emergencies. So it's our position that these emergency administrative orders are appropriate under the constitutional power to enact rules for the practice and procedure of the courts, as long as there is an emergency basis for doing so, because you're handling the practice and procedure of the courts. If the courtroom is closed, if the courthouse is closed, you've got to be able to extend a limitation for somebody to be able to do that.
So then this holding is incorrect, that the court does have the power to toll, if it's emergency as you used, does have the power to toll a statute.
I believe the court does have that power subject to an emergency, but I also believe the court doesn't have the power to grant a windfall extension to everybody, notwithstanding the impact of the emergency.
But you don't find any language that talks about an emergency other than in a rule of court, not in the Constitution.
Correct.
I think that I became concerned with the language Justice Lewis cited to, but in the end they go by strictly construing the administrative orders. We find that they have no application in this case, as the weather emergencies did not in any way delay Ramirez from promptly filing suit. So if we add that caveat, that would be what you're suggesting. You don't suggest the court doesn't have the power to affect the statute if the weather emergency resulted in the inability to file the lawsuit in a timely way. Do you take that position that we do not have that authority, or we do?
I suggest you have the power, the constitutional power, to enter an administrative rule in an emergency situation to allow a litigant or a party or an attorney to perform a task that they physically couldn't have done if the last day of limitations or the last day to file an answer ends up and the courthouse is closed because of a hurricane. I think you have the power to allow that situation to be handled.
Well, wouldn't one way to handle, and I realize you're not here to help us redraft things, but you've now become very involved in this, is that there are rules about computation of time. Computation of time has never been considered to be substantive. It's procedural.
Correct.
We talk about if it's the 7 days expires and there's a weekend included. This doesn't, and this affects statutes of limitations if they expire on a weekend. No one says, well, if you had to file it then, you lose. So it seems to me that what we're doing, although we may have used a broader word that for the tolling, as far as the statute, is we are simply recalculating the time. But don't you think there's a problem with the fact that we have used tolling consistently in our case law to mean stopping the clock, and so now I'm going, I think we have that authority, but what is the answer to the fact that doesn't this conflict with Hankey and the cases that talk about the speedy trial rule in terms of the definition of tolling?
Well, first of all, it's our position the court really doesn't have jurisdiction to review the third district opinion because it doesn't conflict directly and expressly with any other decision of another district court or of this court. If you're looking at Hankey, for example, I don't think you can take a word or a definition out of a decision and say, well, that word is interpreted differently. And the word isn't interpreted differently. The third district decision under review accepts that definition of tolling. They're just saying that you can't apply it when it had no impact to the storm or to the hurricane. We're not going to give you a carte blanche windfall extension. There's no conflict between Hankey and the third district decision because Hankey simply discusses a medical malpractice tolling issue and allows an extension under that. So there really isn't any conflict, either express or direct, between Hankey and the third district decision or between Sullivan, the fifth district's decision, and Sullivan and the third district decision, because that decision concerned the extension of a rule of procedure. And we know there's no issue with the court's ability to extend a rule, and Sullivan dealt with the speedy trial rule.
But how do we interpret in one order tolling in two different ways for the order that we've entered? How do we?
I don't think we're interpreting tolling in a different way. We know what tolling means. The question is,
what does tolling mean?
Tolling means to stop or suspend the running of the clock for a certain period of time, and then it's continued at another time. So the question isn't how you define tolling. The question is whether that order, or the series of orders that are in question here, could be interpreted to allow tolling when the events that you're tolling for had absolutely nothing to do with the late filing. So it's kind of like, let's take an example. Let's say my wife and I are scheduled to go to a wedding, and we have to leave the house at 7 o'clock. Well, I'm home, I'm ready to leave at 7 o'clock. My wife comes in.
Sounds like my husband.
My wife comes in at 8 o'clock, and I say, why aren't you on time? We know that we have to leave by 7 o'clock. And my wife says, I'm sorry, on the way home from work, I had a flat tire. It took about an hour to change it, and I just couldn't be here on time. Well, my response is, I understand that's logical, that's sensible, it was an emergency situation, you couldn't do anything about it. So that makes sense to me. Let's change the facts. My wife comes home at 8 o'clock instead of 7 o'clock, and I say, why are you late? And my wife says, remember that flat tire I had about 8 months ago? That caused me to be late. Ever since that time, I've been running an hour late. I've been getting up an hour late every day, going to lunch an hour late, and now I'm an hour late. Well, to me that response would seem ridiculous.
Well, it's a